Thank you for joining us online if you're there, and thank you to everybody who's here. We have a support night tonight, and we're going to get into that in a second. But I just wanted to give you some upcoming what we're doing. On April 12th, we're doing our Explore Night, and we are using the Bible Project videos to explore the Tanakh, which is the Jewish organization of the Old Testament, and Genesis. How, and just kind of compare it and go with how we think things were different, or it's just a comparison thing, and kind of explore that part of faith. I don't know, are we? We are not streaming that night, so be here in person. It's copyright things, right, with the streaming. Okay. All right. And then April 19th, we have Reform, where we're doing segments of the documentary called 13th, and it's basically the history of racial inequality in the U.S. We are not streaming that one as well because of the documentary, so be here, right? On April 26th, we're going to Connect, and that is Kat is going to be doing that with us, and she's going to be talking about using meditation to connect to faith. And then we'll come back to support in May. So that just gives you a little bit heads up. As always, thank you for being here. Share, like, subscribe. I don't know if we have subscribe, but yeah, the only way we're going to keep doing this is if we get donations. So if you feel compelled to make a donation, either online or if you're here in person, one of those things, on our website, there is a way to do that. And we just appreciate your support in any way, shape, or form. All right. So now I'm going to introduce our speaker for tonight. We are talking about the importance of estate planning. And this is going to be led by Pillara Henderson-Smith. This is her specialty, and she knows all the ins and outs and does it with compassion. So we're very excited to have her here. Please welcome.
Hello, everyone. Good evening. So thank you so much for inviting me to come speak about estate planning. So Victoria's right. This is my thing. This is what I do. So if you have some questions, feel free to ask. What I thought I would do tonight was just kind of talk through the basics. So some of the questions that I normally get, things like, why should I have these documents? What exactly are these documents? So I thought we'd just kind of go over why you should have them, what they are, what sort of the purposes of them are. And so if there's some questions in there, like I said, feel free to ask me. So we'll start with documents that you should have while you are alive. These were considered our living documents, so powers of attorney. And so a lot of people don't usually get powers of attorney, but these are documents that you really need, and you don't realize how much you need them until you need them, right? And then it's usually too late to get them, because you have to have capacity to have these documents. These are documents that allow someone to step into your shoes and to make decisions for you if you have some type of incapacity. So a mental incapacity or physical incapacity. So think dementia, or think if you were in a car accident and you were in a coma and so now you can't make these decisions. But someone still needs to make decisions about your health care. Someone still needs to make decisions about your property, right? So power of attorney for property, right? Can someone continue to pay your rent or continue to pay your mortgage? Can someone continue to pay for your utilities while you are maybe in the hospital and not able to do these things? You think it would be something simple, but it is not very simple. My father was ill. He was in the hospital. He was not conscious. It was during COVID, and I was here. He was in South Carolina. I was not able to pay his rent. I was not able to pay his utility bills. You would think calling the company, giving a name, and saying, I want to pay would be easy. Nope, you can't pay. You're not an authorized person on those accounts. So these are things that you need, and you just don't know how much you need them, like I said, until you need them. What about your health care? Do people know what you would want, what type of care you would want? Is quality of life more important to you, or is quantity of life more important to you? Those are things that you have to communicate to someone. If you don't communicate them, again, they don't know. When my father was in the hospital, and like I said, he was not able to communicate, I wasn't able to get any information. Why? Because of HIPAA laws. You would think as a child, you should be able to find out information. You would think as a spouse, you would be able to find out information. You would be considered part of the team, but you're really not. You're really not. So in Illinois, you really need to have these things in place. You really need to have someone know what you would want, what your desires are, so that things can continue the way that you would want them to continue. Those decisions can be made based on how you would want them to be made. And people say, now, I know I've been in this situation before and I was able to talk to the doctor and I was able to get some information. Well, in some states, we have something called a surrogate, right? So you can become a surrogate. So you need physicians to say that this person is no longer in capacity. And so then they're looking for someone that's going to step up. If there's a spouse, then it would be the spouse. If there's an adult child that's willing to do it, then the adult child. The problem comes is that you're not really part of the team. You'll get some baseline information. And if there's something, that's getting ready to happen that maybe you could make a decision on, but you're not really getting, somebody contacting you constantly, letting you know what's exactly happening, really being part of those decision-making processes. And so, like I said, when my father was in the hospital, he's stable, or he's awake, or he opened up his eyes today, that type of thing. Fast forward a year later, when I was able to actually get him to put documents in place, his care team called me 3 times a day with updates. This is what's happening this morning. This is the medication that happened. This is the treatment. Do we have your authorization for this? Do we not have your authorization for that? So it's a completely different process. And you don't realize it until you're in that situation, how important those documents are. Do your loved ones know, that you don't want to have another treatment? Maybe you've gone through several rounds of some type of treatment and you're like, I'm done with that. I don't want to do that again. Have that been communicated? That's a really tough decision to make for someone to try to make on the fly, that they're not sure, right? Because normally our emotions are very much a part of it, right? And so it's very hard to say goodbye to someone. It's very hard to do something that we think is going to end someone's life. But if that's their wishes and that's their decisions, and if that's your wishes and your decisions, then you need to make sure that you've communicated that. In Illinois, our power of attorney for healthcare carries over just a little bit beyond death. Most powers of attorneys, they cease with authority at your death. But in Illinois, ours carry over just a little bit more, and it allows for the person that you have named to dispose of your remains. So they are able to authorize an autopsy. They are able to authorize organ donation. And then they are able to either have you cremated or have you embalmed and buried. And again, you would want your wishes carried out in whatever those circumstances are and whatever those things are that could be done. So that's something to keep in mind. A lot of people, they think that the powers of attorney carry after death, and they do not. So once a person passes away, you can't use those documents anymore for anything. So then we kind of come into our death documents. And the main one that most people think of is a will, right? Most people have heard of a will, and a will is that document that you would want to put into place. You are able to nominate an executor, and that's the person that will kind of manage your affairs at your death. That person will gather all of your assets, but make sure your creditors are paid, will make sure any bequests that are to be made, those are gifts, go to whom they should be able to go to. Within your will, you're also able to nominate a guardian for your minor child or for your adult disabled child. And so a will is a really important document to have. It allows you to say so over where your assets should go and how things should be distributed. Now, if you don't have a will in place or any other after death estate place, you still have a plan. It's just maybe not the plan that you want. Every state has a plan by statute. In Illinois, the way it would go is if you are married and you have children, and your estate is split 50-50 between your spouse and your children. So the spouse takes half and the children take half in equal share. So if you have 2 children, then they split it. If you have 3, they each get a third. So that's how that would work. If you don't have a wife and you only have children, the children get the 100% and they split it. If you don't have children, you have a wife then or a spouse, then the spouse gets 100%. If there's no children and no spouse, then there's still a plan. It looks and see, are your parents alive? If there's no parents alive, are your siblings alive? No siblings, it's going to go to grandparents and nieces and nephews and on down the line. So for some people, that's not the plan that they would want. So there is a plan. One of the things about a will is that a lot of people think if I have a will, then I can avoid probate. And probate has kind of got this reputation of being this horrible thing, right? Oh, I don't want a probate. Don't want probate. I don't want the state to take all my money. If it goes through probate, the state is going to take all my money. That's not how that works either. Probate is just a legal process. It's a court process just to make sure that assets are going where they should go to. So basically, the judge will look and see, is there a will or not? If there is a will, then that's considered that you have passed away testate. If there's not a will, then you've passed away intestate. Intestate means that you're going to go by the statute. Testate means you're going to go by the terms in the will. So then the judge is going to look and see, have you nominated someone to be the executor? Okay, so then you choose the person that's going to manage your affairs for you. That's a good thing. The judge is also going to say, let's establish who the heirs are. Who is that bloodline that deserves to take underneath? If you did not have a will in place, who would that be that would take? Legatees are the ones that you have named within your documents to say, I want this person to have, X, Y, and Z. So it's going to establish who are those rightful people that should take. Then you're also going to establish whether or not the will is a valid document. Obviously, that would be first. So you're going to make sure that the will is a valid document. It's going to establish the executor. You're going to establish who should take your heirs and your legatees. But then you're also going to be able to do something which a lot of people don't realize. You can kind of eliminate how much involvement the court has, right? Which is a really good thing, right? Because if you are one of these people who's like, I don't want all the involvement, it's going to cost a lot of money, you can eliminate some of that. But you have to put it within your document. So you are able to say, Judge, I want independent administration. They're looking for that language. And you can also say that I want to waive my surety and bond. Now, when people hear bond, they normally think of kind of a criminal bond. It means, and so you put it up and then I'm going to get it back. Don't think about that. Think about an insurance policy. You pay the premium, you never get it back, right? And that's what the surety and bond is. But what it is that you're putting something in place to make sure that if the person that you've named, that they don't run away with your assets, right? And so the surety and bond is normally for about 2.5 times the value of whatever your property is. But if you're naming someone that you trust in your documents and you know that that person is going to do all the right, make all the right decisions and do all the right things on your behalf, then you can waive that. You can say, I'm waiving the surety and the bond. And so that document gives you a lot of control over what happens. And so basically you're just going to court just to open up the estate, open the probate, and then you go back to court one other time at the very end just to say, this is everything that I've done. And so these are all the bills that I've paid, all the claims that I've paid, these are all the gifts that I've given, and the judge looks at it, and as long as everything is good, then the case is closed. And so it's a really finite process that is there to safeguard your assets and to safeguard the individual that should receive the things from your estate. So it's not a bad thing. The one thing about probate, though, is that it is a kind of a long process. So there's a 6-month period that you wait for all claimants to come forward. So right after you open the probate, you're going to notifications and publications that the probate is open for 3 consecutive weeks. And then there's a 6-month period that all creditors have to come forward. The beauty about that is they have the 6 months, but after the 6 months, they can no longer make a claim. So if no one comes forward within that 6 months, then they're just out of luck. Can't come forward, right? And so that's a really, really good thing. If you don't do that 6-month period in there, then there's a 2-year period that people can come forward. You don't want the 2-year period for people to come out of the woodwork and say that there's a claim, especially after you've already given distributed resources, and the assets to whoever you think, because then things may have to be clawed back, or you as the fiduciary, the person that manages the estate, you would be personally responsible. And so you don't want that. So that's something to keep in mind. So usually it's that 6-month period, and then it normally takes about another 6 months in order to pay all the claims and make all the distributions. And so you want to keep in mind, if that is the route that you go, that you have made arrangements so that assets can be maintained during that time. It's nothing like receiving a home and then you can't continue to pay the mortgage on it, or you can't keep the lights on. We're in Illinois, it's really important to keep the electricity and the heat on throughout the winters. You don't want bursted pipes and those type of things, and you want to make sure that the lawn can be kept up. So it's something to think about. You want to make sure that the person that you're putting in place is able to maintain the property, or you have put things in place that the property can be maintained. So that's our death document, and most people have heard of a will. So then the last document that I want to talk about is a trust. And so a lot of people have heard of a trust, and people kind of think that the trust is sort of the the document that you always have to have. Everybody has to have a trust. And I wouldn't necessarily say that, but it's another tool. And so it just all depends on what it is that you're trying to do and whether or not the trust would be a viable document for you and for your assets and your estate. So a trust there's lots of different types of trusts, say that. And the one trust that usually people are thinking of when they think about a trust is a revocable living trust. And it's exactly what it sounds like. You're alive, and so it's living, right? And it's revocable, and so that means that you can decide that you don't want it. You can make changes to it. It's a very flexible document. It's a really cool document in that you can establish it yourself, and you would be considered the grantor of the trust. But then you need someone that's going to manage the trust. That's the trustee. You can also be the trustee. And then there's a beneficiary, and you can be the beneficiary of your trust, right? So when you are establishing it in the very beginning, it doesn't change a whole lot of structure of what happens. Sometimes people think, well, if I put things in trust, then it's going to be this whole complicated thing. In the beginning, no, it's not really complicated at all. So like I said, you can establish it, you can manage it, and you can also be the beneficiary of it. So it's a really good thing. The thing about the trust is that you are taking assets out of your personal individual name and you are putting them into the name of the trust. And the trust is a separate entity. And so it's really good if you have multiple properties within a state or in different states, because real property is one of those things that it has to go through the probate process in order to have clear title, which means that you have to open up a probate in the county of where the property is located. So if you have property in Illinois, you would need a probate in Illinois. If you have property in Florida, you would also need a probate in Florida. But if it's not owned by you as the individual and it's owned by your trust, no probate. Because when you pass away, it's not, that property is not connected to you, the individual, it's connected to your trust. And so whomever you've named as the successor trustee, and that's just the person that would be the trustee after you, the successor, then that person is able to follow whatever your wishes are that you have put into the trust. So you want to think about the trust sort of like a wallet. And the wallet governs all those things that you have put into the wallet. So you can come up with whatever your special rules are for those assets that are in the wallet. So you can say, trustee, I want you to maintain this property forever. Or trustee, I want you to sell this property and I want you to give the proceeds to my children. I want you to set up accounts for my grandchildren. Whatever you want it to be. Because it's not connected to you directly, it gives that flexibility and it gives the ease of being able to manage the property in the different locations in the different states. And so it's a really, really good thing. It's also great because you can say, if I become incapacitated, this is how I want you to spend my resources for me. I want you to continue to maintain my current lifestyle. I want you to continue to take me to the the nail salon every week. I want you to continue to take me to the barbershop every week. I want to continue to pay for my grandchildren to come visit me every summer. I want to continue to go on the girls' trip. I don't want to go into assisted living. I want you to use my resources for in-home 24-hour care. So you can say whatever it is pretty much you desire within this document. That's for your, your benefit in the lifestyle that you would want to lead. When we are alive and the assets that we accumulate, whatever they are for us to have the best quality of life that we can have. And so the idea is to be able to communicate that to someone. This is the quality of life that I want. It is okay to use my resources for these things. But then you can also say, at my death, now I want you to give these resources to this person or this organization. And if you have minor children or if you have disabled adult children and you want to be able to continue to care for them as if you were alive, but you're not, you can do that through the trust, right? You can set aside resources for your minor children and you can say, while they are still minors, trustee, this is how you are to spend the money for their benefit. You can continue to spend for their benefit the same way I would. That doesn't mean it has to be this equal, crazy distribution. We don't, as parents, go to the store and every time we go to the store, we buy exactly the same thing for every child that we go, right? And so you can say, continue to do it exactly the same way I would do it. When this child needs money to go on the field trip, it's okay to spend the money for that. When this child needs a new pair of shoes, it's okay to spend the money on that. But then maybe you say, well, once they are all, say, 18 or 21, then I don't no longer want you to spend resources that way. What I want you to do is take everything that's left and I want you to split it between them. And so now they have their each individual trust. And now you can say, but I don't want them to have it outright just yet because I don't think they're quite ready to have a big lump sum. So maybe we just continue to pay for their education and they are allowed to have the income from whatever being produced in their trust. Maybe once they turn 21, they can have a third of what's in their trust. When they turn, 30, they can have half of what's left in their trust. When they turn 40, they can have all of it. Or you can say, make it available to them, but they don't have to take it out. It's not this magic date of once they turn 21, you write a check. They're allowed to come and say if they need it, but if they don't need it, leave it there. The real thing about that is because it's out of their control. And because it is out of their control, it's not considered theirs. And so it kind of has a little bit of creditor protection. So if they are sued for some reason, maybe they were in a car accident, they didn't have quite enough coverage, maybe they're going through a divorce, those assets aren't considered theirs, but they're still there for their benefit. As long as they don't take the money out and put it into their bank, considered part of their assets. The trustee can still continue to use those funds for their benefit. Maybe the trustee pays the tuition as opposed to giving them a check to take to the school to pay the tuition. It's a direct thing. And so those assets never get counted as theirs. And so there's a lot of flexibility and a lot of good things that come with the trust. You can have a cutoff date, or you can have it, for a very long time. It can definitely be a thing that can be used for generations. And so a legacy instrument that you can use. And so there's a lot of different tools. So those are main documents that usually when I get questions, what should I be thinking about? What should I do? There's lots of other documents, but those are normally the main ones. Every estate plan is different. It's unique to what your individual lifestyle is, to what your goals are, what it is that you are trying to accomplish. It doesn't necessarily mean that everyone needs a trust, like I said. I think that everyone needs a plan, right? But what that plan is may look different for every individual. So it all depends on what you have. I know when I talked about the will, I said that you need to make sure with real property, it's going to have to go through probate or in order to have clear title. Well, there is something in Illinois that I just want to touch on briefly. We have something called a transfer on death instrument. And the transfer on death instrument was put into place usually for individuals who really their only main asset is maybe their home. And so if the only asset really is their home and everything else maybe has payable on deaths or transfer on deaths or beneficiaries, and so it almost doesn't really make sense that you would have to open up a whole probate just for this one piece of property. And so now Illinois has something called a transfer on death instrument. And what you can do with that is that you can name a beneficiary for the property, right? That document gets recorded with the recorder's office and where the property is located. Now, the person that you name on that document, they have zero claim to the property while you are alive. And again, you are able to revoke the document if you want to. But at your death, what that document allows is for them property as a matter of law, they are accepting it as is. So that means subject to any mortgage, subject to any liens that may be on the property, property taxes, all those things. So as is. But they don't have to wait that 6-month period. So if it is an issue of this property can't be maintained for the 6 months and we really just want to sell it, then it allows that flexibility in order for you to do that. You always want to think about who you are naming, though, as a beneficiary on something like that. If for some reason that document fails because the person doesn't want to accept it, then the property would just pass regularly through your estate. But that is just something that definitely is in place. That's another option that if you are doing a will, that you may want to also consider the transfer on death instrument. Do I have any questions from anybody? I kind of went over a lot.
We do. We usually break after we're done speaking, and then we kind of sit around the tables.
Okay.
And questions. So thank you
All
very
right,
much.
great.
That's awesome.